Hello and welcome to the EDRM Global Webinar channel. My name's Mary Mack. I'm the CEO and Chief Legal Technologist for EDRM. Today's webinar is an EDRM collaboration with our trusted partner, eDiscovery Today. It's called Important eDiscovery Case Law Decisions for November 2023 with our faculty experts, Doug Austin, Tom O'Connor, and the Honorable Judge Andrew Peck. We welcome your questions and feedback in the console. Questions will be answered both during and at the end of the webinar, and this webinar will be available for replay at your convenience for the next quarter, as are all of our EDRM webinars. Kaylee Wallstead, EDRM Chief Strategy Officer, is here with us. Kaylee, will you please tell us what resources are available on this very special day?
Absolutely. And I always count the days until the important eDiscovery Case Law Decisions webinar. So a quick introduction to the On24 platform, which has so many more ways for you, our audience, to engage. If you look to the right of your screen, you'll see there's a console with a question mark, a paperclip. If you click the question mark, this is where you can type in your questions for today's faculty, and we highly encourage you to do so. Slides will be made available after the webinar has concluded, and there is a paperclip. If you click that for related content, you'll see today's resources curated just for you. On24 engagement tool descriptions for you to download to help you better engage. A link to subscribe to eDiscovery Today blog and never miss a thing. A link to learn more about the Honorable Judge Peck and how to engage with him. And you can check out Tom O'Connor's spicy, newish book, eDiscovery for the Rest of Us. And save your seat for next month's Case Law edition on eDiscovery Today, the top 5 cases of 2023. It's definitely a do not miss. And up next on EDRM's webinar channel, November 28th, save your seat for Craig Ball's presentation on finding common ground on ESI protocols. Speaker bios can be clicked and popped up to learn more about today's faculty. And just like Zoom, you'll see a smiley face emoji, and there's many more reactions. And we highly encourage you to engage with them. During the webinar, we're having a lot of fun with them on this platform. If you see the Twitter bird, you can follow EDRM and eDiscovery Today on LinkedIn. And back to you, Mary.
Thanks, Kaylee. And for our listeners, we've got Doug Austin. Doug is the founder and editor of EDRM Trusted Partner eDiscovery Today. He's an established eDiscovery thought leader with over 30 years experience providing eDiscovery best practices, legal technology consulting, technical project management services to numerous commercial and governmental clients. And Doug has published a daily blog since 2010 and has earned JD Super Awards 3 times. And we also have Tom O'Connor, hailing from the great city of New Orleans. For over 30 years, Tom has stewarded the Gulf Coast Legal Technology Center. He's written, as it has been put, a newish book called eDiscovery for the Rest of Us you can find on his Techno Gumbo blog. And the Honorable Judge Andrew Peck is a Chambers-ranked senior counsel at DLA Piper, where he advises on copyright and trademark matters, also serves as a resource for the firm and its clients on litigation strategy and eDiscovery issues from a judge's perspective. Judge Peck retired as a United States magistrate judge in the Southern District of New York after 23 years, writing many of our first eDiscovery opinions, and then later he's written on very important issues like boilerplate objections. We'll see a little later. Our boilerplate or 502D orders and technology-assisted review. And over to you, Doug. We've got some cases.
Indeed, we do, Mary. Thanks. And by the way, happy birthday, Kaylee. So, yes, we, believe it or not, at the end of this hour, we will have covered 18 cases in 6 weeks and a day. So if we sound tired, that's why. So, of course, we have 6 new cases this month, as we do pretty much every month, including permissive inference sanctions for destruction of video, sanctions for failing to record and preserve live streams, sanctions for violation of a protective order, forensic imaging of devices in an IP case, sanctions for overly narrow searches to retrieve emails, and production of individuals' entire social media data. As this is the last case law webinar of the year for new cases, we grabbed a couple of great cases from earlier in the year we missed. And just a reminder, we do welcome questions, and we'll try to get to as many as we can. And we'll send out a copy of the slides after the presentation, so look for that too. Of course, any ideas expressed by us here today are our own, not those of our organizations, clients, or partners. I'm thankful that I'm done reading disclaimers for the year. Well, almost. And before we get started with these cases, here's a quick note about the webinar format and sources of cases. This is the latest in a series of monthly webinars about case law, and the cases we discuss each month will be those covered on eDiscovery today. We provide links to each of the stories about the cases, which in turn have a link to the actual case ruling, where you can check out the full ruling itself. These case law rulings are available courtesy of Kelly Twigger's eDiscovery Assistance site, which is a great resource not only for case law, but also for federal and state rules, checklists and forms, and a glossary of legal and eDiscovery terms. eDiscovery Assistant has over 32,600 lifetime federal and state case law rulings, and they add as many as several hundred cases a month. eDiscovery Assistant is the definitive source for eDiscovery case law out there. So with that said, let's get into the cases. Our first case is a state case that was appealed. It's unpublished, and it was suggested by Judge Peck. Here, the plaintiff stepped forward onto a slippery area of the floor at a Rite Aid and fell, experiencing serious injuries. The floor manager for the store acknowledged her signature on the receipt for a preservation letter sent by the plaintiff's attorney just 13 days later, which stated, "The purpose of this letter is to advise your company not to destroy, conceal, or alter any information stored in electronic form or generated by your company's computer systems or electronic devices from the date of our client's injury." Later on, the plaintiff's attorney asked the floor manager if she or anyone at Rite Aid followed through with preserving any evidence from electronic devices, including videos from the store on June 3rd, 2018. She replied, there wasn't any. She clarified there were cameras inside the store, but not where the client fell. No one looked at the video, including people from corporate. While aisle 4, where the plaintiff fell, was not covered by a working camera, there were cameras in other locations in the store that would have shown the plaintiff walking into the store and leaving on a gurney, the plaintiff potentially crossing the middle aisle to get to the aisle where the Benadryl she was buying was located, whether employees were conducting inspections in other parts of the store, and whether anyone went into the stock room and grabbed a broom. Ultimately, over the defendant's objection, the trial court instructed the jury with Judicial Council of California Civil Jury Instruction 204, which provides, you may consider whether one party intentionally concealed or destroyed evidence. If you decide that a party did so, you may decide that the evidence would have been unfavorable to that party. The jury found for the plaintiff, and naturally, the defendant appealed. Regarding the issuance of CACI 204, the appellate court stated, Rite Aid contends that the preservation letter was not legally sufficient to impose a duty on it to preserve the video, and that absent such a duty, CACI 204 was not warranted. We find the letter sufficient to impose a duty to preserve. In its ruling that affirmed the adverse inference sanction, the appellate court stated, after being asked by Apasaga's attorney to preserve video recordings for June 3, 2018, Rite Aid chose to destroy the videos. The relevance of videos of other parts of the store was readily apparent from the bare fact of Apasaga's slip and fall. These facts are more than sufficient to support an inference that Rite Aid destroyed the video to prevent it being used in litigation. As a result, the judgment was affirmed and the defendant was ordered to pay costs on appeal. So, Tom, what do you make of the argument from Rite Aid that the broad preservation letter didn't ask for anything relevant? Is this a grasping at straws argument?
Well, close to it. If it's not exactly grasping at straws, it's Jack hanging on to the board in the sinking of the Titanic. I looked at 3 or 4 sample letters on various sites that are out there, sample preservation letters, and every one of them had the wording, quote, take action to preserve all potentially relevant ESI, end quote. Okay, so that certainly is the standard. The The fact that they didn't, should that destroy the duty to preserve? No. I think two things. First, the duty to preserve isn't contingent upon the receipt of a preservation letter. The duty to preserve is the duty to preserve. But also, as the appeals court pointed out, and you just read, the appeals court kind of did their version of the NFL Monday Night Football come on man video clips and saying, look, the fact that somebody slipped and fell gave facts that, as it says right there on the screen, more than sufficient to support an inference that they destroyed video, but also that they knew or should have known that any video showing inspections or maintenance of the store aisles or showing that the individual had difficulty walking would be relevant. Like this was just it was a come on man moment. So yeah, I mean, not their best argument.
Yeah, and great point. I mean, just because it's not just a letter that it starts your duty to preserve. It starts when it starts. So great point, for sure. So Judge Peck, given that there weren't any cameras focused on where the client fell, do you think the court's statement regarding an inference that Rite Aid destroyed the video to prevent it being used in litigation is accurate? Couldn't the failure be attributed to negligence?
I guess one question would be, what did Rite Aid argue? And we don't really know that. Clearly, the fact that they preserved nothing of the video is pretty damning. If they had saved showing her entering the store, and or exiting the store on a stretcher, but nothing else, then they made the wrong call. The fact that they did nothing, I don't think the court was wrong in going as far as it did. Could it have been just corporate negligence? Yeah, it could have. And I wonder, and California is particularly, consumer friendly generally. And I wonder if this was a decision to encourage stores, particularly chain stores, to develop better practices with respect to preserving video when somebody gets hurt in a store.
Right.
Well, yeah, absolutely. And speaking of practices, Mary, we've seen several instances of this year of parties unilaterally deciding what video is responsive without outside counsel involvement. So how should corporations handle situations like this when they receive preservation letters, and when should they bring in outside counsel?
Well, I was just gobsmacked that the preservation letter got in there and it got signed by somebody from
right.
So I would think counsel, at the very least, inside counsel, should be notified at that point, and certainly some communications go out around what the preservation obligations are. I think retail has been really hit hard. The pandemic hit them hard, and now there's a rash of shoplifting and whatnot. And the video, if you go into a retail location, you can see the video that's there to deter what they call the shrinkage, the shoplifting. And I can only think that there's some great procedures if somebody has shoplifted to get that video and save that video. And so maybe that should just be extended to things like slip and fall and situations like that. I think that would probably be the best, easiest solution.
Yeah, great point. That certainly benefits them to save the video and the case when there's shrinkage. It would be good to extend it. And I think didn't Rite Aid file Chapter 11 or something recently? So they are struggling as a company. I believe that that's right. So yeah, it's certainly an interesting case, and certainly a similar circumstance we've seen before. So we'll move on to our next case, which is about a house party. Well, actually, it's about copyright infringement claims over defendant's sequence of live-streamed episodes named House Party, and this case was also suggested by Judge Peck. The plaintiff held the copyright for House Party, a concept envisioning a broadcast from a New York City brownstone featuring an exclusive and engaging after party with musicians and celebrities. This idea was initially proposed to the defendants, including the BET network, who rejected it twice. But then they eventually produced their own series with the same title during the pandemic with a bit of a different format, guest broadcasting from their homes to entertain others during the quarantine, which was live streamed to Instagram Live and Facebook Live. The plaintiffs sought adverse inference sanctions for the defendants due to their failure to record several episodes of the BET series during live streaming, resulting in only 39 out of about 90 episodes being available for production. The plaintiff maintained that since they had informed one of the defendant's lawyers of their intention to initiate claims related to the BET series, every episode that wasn't recorded and preserved after that notification constituted a breach of the defendant's duty to preserve evidence. Did New York District Court Judge Catherine Filo agree with that? Not so much. She stated, the notion that BET would appropriate plaintiff's intellectual property, which relied on social media applications that are themselves constantly evolving, and keep it in its back pocket for years until an unforeseen global pandemic stranded viewers and hosts at home, strains credulity. She also stated that plaintiff has also failed to show any violation of preservation obligations by defendants. A failure to create records as opposed to the destruction of records that were kept is not spoliation. Because preservation obligations do not include an affirmative duty to produce new records, defendants' failure to implement a practice of recording the BET series live streams, even after receiving the alleged infringement notice from plaintiff, cannot be the basis for a spoliation claim. The court will not create an exception for live stream content to the general rule that parties have no obligation to affirmatively create new records. And she said that even if the court to find that plaintiff could establish defendant's failure to preserve the live streams with a culpable state of mind, plaintiff still cannot demonstrate that the lost evidence would have supported its claims, and as such is not entitled to an adverse inference. So, Judge Peck, if the claims had been found to have had merit, should the defendants have been held accountable at some level for failing to record the live streams once they were informed that the plaintiff planned to initiate claims, if not for spoliation, then for something else?
Well, I'm not quite sure what else it could be. I suppose if the 50 or whatever that were recorded showed copyright infringement, there might have been an assumption that all the episodes infringed the plaintiff's copyright, so in connection with damages. But two things. One, nothing in the facts, at least in the published opinion, would indicate that the plaintiff could not have recorded these live streams themselves. It's not something, from what we can tell from the opinion, where you needed to be a subscriber or whatever. Mm-hmm. Secondly, and I agree with the court here, there's a difference between having ESI and then getting rid of it, destroying it, spoliating it, and creating an obligation to create something that isn't originally recorded. I mean, the next argument would be, well, you reasonably anticipate litigation or you're in litigation. If you send an email, you've got to produce that. So you now have to record all of your telephone conversations or all of your face-to-face meetings at the water cooler.
Right.
I mean, there's a limit to what should be done here. So. Mm-hmm.
Yeah, absolutely. Great point. So certainly the plaintiff recording the live streams would be one thing, but Mary, assuming the claims had merit, what, if anything, could the plaintiff have done else to help their case?
Yeah, well, certainly, as Judge Peck said, the having the plaintiffs live record it themselves, but also are there any witnesses? I mean, how do they know what was on it? And do it old school with an affidavit or through a deposition or something like that. But the other thing is, Facebook and Instagram have a fairly robust record keeping, especially if there's money involved, like ads. And so they could have just bought an ad on it and got the records that advertisers get of the audience data. The other thing is promotional copy. How did they promote this this live stream? What kind of online discussion happened?
Yeah.
You might find out what happened during the live stream in some of those things, and that is electronic. So.
Mm-hmm. Yeah, absolutely. Oh, great point. I'm shocked that Facebook and Instagram are trying to make money with their operations, but go figure. So Tom, many of us are involved in live web meetings that aren't recorded either. So, which of course that's kind of similar to a live stream episode, as Mary pointed out. So, what advice do you have for our audience to gather as much information as possible for a meeting or a live stream that wasn't recorded?
Well, and maybe they did this. I don't know. This argument just centered around the live stream, but kind of to piggyback on what Mary was saying, there probably was a slide deck. We're streaming something now, and you every month produce a fairly detailed slide deck. There probably were emails that went back and forth inside the company about the presentation or what was going to happen. I mean, seems to me there's should have been some secondary ESI surrounding the live stream that would have been ripe for discovery. And so I think in terms of getting at that information, think about all the ESI that may be relevant. Messaging, right? What if they were using some sort of collaborative tool to have discussions? It just seems like there could have been a lot of information that led up to the live stream that should have been preserved just in the ordinary course of business, or at least might have been preserved, and you could go after that. So with regards to meetings, I mean, I think that's a little different. And the judge was certainly talking about this being about live streams being different. If you're having regularly scheduled meetings, excuse me, whether they're internal sales meetings or whatever they are, I mean, recording those is incredibly easy. Zoom just has a button someplace where you can click on record this meeting, and everybody's put on notice that they're being recorded. A notice goes out to all the people. I presume that On24 has something similar. I recommend you do record and keep them, but again, make sure that any discussions that have gone out in notes, in emails, in any sort of discussions, or especially contemporaneous discussions, are trapped. And again, as Mary said, interview attendees. Talk to people who witnessed the live stream or maybe even were part of the live stream, but try to interview those people and get to the discussion that way. So there's a lot of different ways to skin this cat, if you'll pardon the mixed analogy.
Sure.
But I do want to clarify or comment on something Tom just said. In the regular course of business, people who because of COVID started, we can record our Zoom meetings. Let's just record them.
Right.
And then no one ever looks back at any of those recordings until litigation hits and you've got to go through, 1,000 hours worth of that. And that's a disaster. So please don't record regular Zoom or Teams meetings when there is no reason to do so. Or if the old, not every salesperson can be there, we want them to come listen to it afterwards. Well, A, do they ever? But B, that means after a week or two, it's outlived its usefulness. Get rid of it before litigation is reasonably anticipated.
Yeah, great advice. And certainly a lot of great ways to get that information for live streams and meetings. One of the ones I was going to suggest is if the meeting isn't recorded, at least seeing via the calendar that meetings were scheduled and who the participants were, so you could go after interviewing those people. So Certainly a lot of different ways to go after it. Got a couple of questions here. I'm going to combine the first one. Was the plaintiff the owner of a valid copyright, and did the defendant copy original expression from the formal copyrighted work?
Mm-hmm.
Go ahead.
As somebody who is a copyright and trademark lawyer, when I'm not focusing on discovery, they probably had a valid copyright or a copyright. All you need to get a copyright is to file something with the Copyright Office and pay the $2, or I'm sure that's not the amount, but clearly the defendant did not copy any of the expression other than the title, which is not a protectable element in a copyright lawsuit. And clearly the court found that the themes and expression of the two ideas were totally different. That defeats a copyright claim right there.
Yeah, certainly. And another question, if the live streaming has a regularity of broadcasting and is publicized to the public at large, could there be an implied copyright?
There is no such thing as an implied copyright. There could be a common law copyright, but the issue here really wasn't the copyrightability of the defendant's live stream broadcasts, but rather whether those broadcasts, copyrighted or not, infringed a valid copyright of the plaintiff, and the court found that it did not.
Yeah, absolutely. All right, great questions, and we'll move on to our next case, which was a case that went international and not in a good way. In this case, over the plaintiff's claim that defendant failed to pay royalties owed under a patent licensing agreement, the defendant filed a complaint against the plaintiff in the Commercial Court of Vienna, alleging plaintiff violated the parties' 2016 non-disclosure agreement by sharing EVG's confidential documents with third parties, which they submitted in that case to support their cause. Ironically, in this case, the parties had a protective order which stated a receiving party may use protected material that is disclosed or produced by another party or by a non-party in connection with this case only for prosecuting, defending, or attempting to settle this litigation. Such protected material may be disclosed only to the categories of persons and under the conditions described in this order. So the plaintiff filed an application for a temporary restraining order in order to show cause why defendant should not be held in contempt of court for violating the protective order, and preliminary anti-suit injunction should not issue to enjoin EVG's Austrian suit. The court converted plaintiff's application for a temporary restraining order to a motion for a preliminary injunction, which was vacated as moot after the defendant dismissed the Austrian action against plaintiff without prejudice, but still held a hearing on plaintiff's motion for contempt sanctions. And contempt, California District Judge Jacqueline Corley found, stating, a party's violation of a specific and indefinite court order constitutes civil contempt. Sigen, as the party moving for civil contempt sanctions, bears the burden of proving EVG's violation of the protective order by clear and convincing evidence. Sigen has met its burden. The plain language of the protective order precludes the use outside this litigation of confidential material produced in this litigation. The unrebutted evidence EVG told Sigen it sued Sigen in Austria because it was willing to escalate the parties' dispute on principle shows EVG's improper purpose in its misuse of the confidential material produced in this litigation. There is nothing technical about EVG's violation. It was not done in good faith, and it was a blatant violation of the protective order. So Judge Corley granted plaintiff's motion for monetary contempt sanctions and prohibited defendant from using the associated email correspondence and any other accompanying attachments produced by Sigen to launch any other litigation against Sigen or for any other purpose outside this litigation. She also ruled that defendant must return the documents used and must sign and file a declaration that all copies were returned and that defendant didn't possess any copies of these documents in any form. So, Mary, we see protective orders issued frequently to protect sensitive or personal information in litigation. So what advice do you have for our audience on how to develop a protective order that sufficiently protects their interests?
Well, protective orders can be very, very scary when you look at them and you know you have to sign them. But I'd say the first thing with the protective order has to be understood by those who are covered by it. So certainly the attorneys that are negotiating it understand it. But it also may need to be put into English for the staff that is supporting the attorney to also understand what their obligations are. The other thing is that it needs some teeth. Like, what happens if you violate it? Is it just a, oh well, so sorry, my bad, or is it, or do you can you be dragged into court, and are there damages and those types of things? And then the other thing is what material is covered here. It was very specific. It was the material in that lawsuit. And what's impermissible? Can you use it in another suit, even in related material, on a related claim? And so just be very, very careful of the language that's put out in there.
Indeed. Great suggestions, because it does have to have teeth. Tom, when it comes to violations, they're not always as egregious as this. They can be much more subtle, such as sharing documents under a protective order with an unauthorized party. So what can parties do to ensure opposing parties are following the protective order, if anything?
Well, I really think it depends on the type of case and what things are going on here. I mean, it kind of helps when the party violates the protective order by suing you in another court. Do you have a way to monitor what's going on? As Mary said, you have to very carefully look at the language of the order and what's permissible and what's not. The court itself said that the burden's on the moving party to show that the action that was taken was not based on good faith or a reasonable interpretation. In this case, the court, as you noted, said there's nothing technical about their violation. It was not done in good faith. It was a blatant violation of the protective order. If you don't have quite so blatant motions, especially in a non-commercial case, how you root those out, I think, is going to be difficult. I guess my suggestion would be enlist the aid of a good attorney in this area, like Judge Peck, and get them involved so that they can take whatever action they've deemed necessary in other cases to do that sort of monitoring.
Yeah, absolutely. Always good advice. So Judge Peck, in this case, the defendant was prohibited from using the email correspondence in any other litigation. What practical ability does an American judge have to keep a party from using materials in a foreign court if they were to decide to defy an order like that?
Well, if they defied the order, they were already found in contempt here, not to mention their violation of Rule 1.1, because it's pretty clear the judge was really pissed at them for what they did. But, the court could not act against the Austrian proceedings directly, but it certainly had jurisdiction over the party that had signed the protective order, and therefore all the usual sanction remedies, contempt remedies, ultimately civil contempt. You put somebody from the defendant company in jail until they agreed to dismiss the Austrian action, something like that. If the case started, in a U.S. court with a U.S. protective order, the court has a certain amount of power over the parties. Now, if the party somehow was in the U.S. Enough to be the defendant in this case, but really, withdrew from doing business in the United States, and there was nobody to act for the court to act against, then it would be much more problematic.
Yeah, absolutely. And so certainly an interesting one. I think we've seen a couple of instances where maybe improper sharing, but filing a case in a foreign jurisdiction was kind of unique. So one of the reasons we thought this was a good case to pick. So we'll move on. Okay,
Sorry, Doug, I would add that it is not unusual for parties when there are other, related cases floating around to negotiate in the confidentiality order as to whether material from one case can be used in another or not. And then whatever the parties agree upon or the court orders with respect to that, you better comply with.
Yeah, absolutely. It's an order, so of course. Yeah, great point. All right, so we'll move on to our next case in which the plaintiff alleged the defendant misappropriated trade secrets, among other things, after a business relationship between the two parties soured. The plaintiff directed its engineers to suspend their development work on the joint entity and removed defendant's ability to access the Google Drive containing its IP that had been previously shared. However, unbeknownst to the plaintiff, 3 defendant employees downloaded a total of almost 80,000 files containing plaintiff's IP from the Google Drive before plaintiff had a chance to remove access. Doesn't take an Einstein to know that's a lot of files. See what I did there? I couldn't resist. Anyway, plaintiff moved for expedited discovery in connection with plaintiff's emergency motion for preliminary injunction, requesting that forensic imaging be ordered for the computers, storage devices, and cell phones of 3 defendant employees and the defendant individual responsible for its relationship with D3, the subcontractor that assisted with R&D for the project. Noting that good cause for early discovery frequently exists in cases involving claims of infringement and unfair competition, Kansas Magistrate Judge Teresa James stated, the court finds plaintiff has demonstrated good cause for expedited discovery. First, plaintiff's motion for preliminary injunction is currently pending. Second, the court finds the expedited discovery requested as further limited by this order is reasonable and proportional to the needs of this case. The court finds plaintiff has shown good cause for a forensic imaging of the work computers and storage devices utilized by defendant's 3 employees allegedly responsible for downloading the files from the Google Drive and the work computer and storage devices utilized by the individual at ADAC for its responsible for its relationship with D3. Apparently, the good cause doesn't extend to mobile devices, where Judge James stated, plaintiff provides no legal authority for its request to examine the personal cell phones of the 3 individuals, and it does not explain why it is necessary to conduct an inspection of their cell phones in addition to the computers and storage devices that those employees utilize. The court finds plaintiff's request to image these employees' personal cell phones overly broad, unduly burdensome, and unduly intrusive, given the disproportionate amount of personal information totally irrelevant to this lawsuit that is likely on these individuals' personal cell phones. Further, given the heavy reliance many cell phone users place upon their devices, the court finds the request that these individuals produce their personal cell phones to a third party for an unspecified amount of time overly burdensome at this stage in the case. Additionally, the court questions whether defendant's employees' personal cell phones are within the possession, custody, or control of defendant, that it could be compelled to produce them for imaging. So, Tom, what could the plaintiff have done, if anything, to convince Judge James to authorize forensic imaging of the cell phones?
Well, I thought she laid it out pretty well there, especially in that last paragraph on the screen. I mean, she made it quite clear. They didn't establish that they were used for work at all. Even if they were used for work, could you show that the amount of work usage overcame the what she called a disproportionate amount of personal information, totally irrelevant to the lawsuit? I think that harkens back. I can't recall if she cited to Riley versus California, but her wording certainly harkens back to Chief Justice Roberts in that case in 2014, where he said, the amount of information that Americans have on their cell phones, for many of them, the quote unquote privacies of life, do not make that information less worthy of the protection for which the founders fought. It's a high burden, I think, to get over, to make it non-intrusive. And then third, as she said towards the end there, are they really in the possession, custody, or control of the defendant that they could even, be compelled? That would, of course, have a lot to do with how much they were used for work. I guess you'd have to look into see if there was a BYOD policy at the company, and that people were routinely using their personal cell phones for a large amount of work, and that was in some way captured in a policy at the company. But they did none of that. Mm-hmm. She clearly was just not going to entertain it.
Yeah, certainly that was clear. You're absolutely right. Yeah, and of course the possession, custody, control consideration was one we talked about in the Hormel and Ray Pork litigation a few months ago, where the court ruled there that the personal cell phones weren't in their possession, custody, control, but the plaintiffs were smart enough there to subpoena the custodians directly for them, and still were awarded the ability to go after that data. So, so Judge Peck, given what we know about IP cases and potential communications related to them, would you have denied the request to image the cell phones?
Based on this record, probably. Mm-hmm. Now, remember, this is an institutional, well, I'll put it this way. The parties had a business relationship, and then they went their separate ways. So plaintiffs should have known from that relationship whether defendants' employees used cell phones to communicate. And that was a missing factor here. Mm-hmm. If I would have ordered imaging, it would have been to require the parties to hire a forensic consultant, a Dan Regard or a Craig Ball or whoever, and image only select parts of the cell phones and not produce that to anybody without further court order, but at least to preserve the data, and then have come up with, similar to the taint team approach in criminal cases, having somebody appropriate go through it to figure out what is relevant to this litigation versus what is personal data. Mm-hmm. And, Kansas is not the end of the world. In fact, it's the middle of the U.S. But, I'm sure they could have come up with a vendor to plug into the employee phones and not have the phone out of the employee's possession for more than half an hour or so.
Yeah, well, I was just about to ask Mary about that. Obviously, Mary, one of the reasons Judge James cited for denying the request to image cell phones was that production of the cell phones for imaging an unspecified amount of time was overly burdensome. So, especially given what Judge Peck just said, do you agree, or do you think collection methods have improved so that it shouldn't have to take so long?
I think it's absolutely right what Judge Peck said. Somebody could just plug in, so an on-site collection, and because he narrowed the collection, it's not a full collection, it's a selective collection, a logical collection, if you will. And so it would not take that much time. And there's also the remote option available now. We have a couple of our trusted partners have platforms that many in the eDiscovery ecosystem are using. Celebrate and Mode 1 both have the ability to do these things. So I think it's like embedded objects were just too hard, and so we didn't do them for a while. But we can now, and we do embedded objects. I think the same thing with cell phones. The technology window has moved.
Mm-hmm. Yeah, I agree. Question from the audience: would it have made sense for the plaintiff to have attempted to take depositions of the three key employees limited to their usage of personal cell phones for work purposes, and whether there was any relevant information on their personal phones?
The question. Yeah. I mean, this was leading up to a preliminary injunction. Unclear how much time they had, unclear whether doing that would have just given the employees more time to wipe their device. A lot of facts we don't know, but certainly whether from the plaintiff's employee knowledge of what the defendants did when they worked together or from depositions, getting that actual information in front of the court would have made all the difference.
Mm-hmm. Yeah, absolutely. Yeah, one thing I think the court did mention was that I think it took 6 months for the plaintiffs to realize after they were looking at a log of the use of the drive. So obviously 6 months was a fair amount of time for tracks to be covered, for lack of a better way of putting it. So great point. And we'll move on to our next case, which was brought by former employees of the defendant who were terminated and claimed they were denied religious accommodations in connection with the COVID-19 vaccines. In it, the plaintiffs first filed the case pro se in New York State Supreme Court. Subsequently, the case was removed to this court, and the plaintiffs' originally retained attorney subsequently withdrew, citing sharp disagreements between counsel and plaintiffs over the manner in which discovery should be conducted in this case, and cited plaintiffs' failure to cooperate with counsel as the basis for withdrawal. As New York District Judge Louis Lyman noted, almost from the start, plaintiffs delayed producing documents and information in response to defendants' discovery requests. These delays resulted in fact discovery being extended multiple times, even after new counsel for plaintiffs took over. Their first production was 1 day late, then they continued to produce additional documents here and there until the court issued another deadline. Then 3 days after that, plaintiffs produced a staggering 1,082 additional pages of documents. Additionally, part of the defendant's motion to compel was the claim that plaintiff's counsel had run overly narrow search terms for emails from only 3 accounts and had indicated that they might refuse to use other search terms or to search other relevant document repositories. Regarding that dispute, Judge Lyman stated, plaintiff's counsel blames their plainly inadequate January 2023 production on defendant. They state that they repeatedly attempted to negotiate search terms with the New York Fed before running searches, but that the New York Fed requested that plaintiffs run search terms on its own determination. While it is true that parties are generally encouraged to meet and confer on the appropriate search terms to employ for ESI discovery, the producing party, even absent agreement or discussion about the appropriate terms, still has an independent obligation to craft search terms to fulfill the requirements of Rules 26 and 34. There is little question that plaintiff search terms were not reasonably calculated to lead to production of documents relevant to their claims or defendant's defenses. Notably, prior to applying any search terms, plaintiffs only searched Gardner Alfred's and Diaz's emails between one another and with 5 other individuals. Plaintiffs offer no justification for narrowing the emails searched in this manner. Plaintiffs also applied extremely narrow search terms to these emails, which are the search terms you see there in the last bullet point. Judge Lyman ultimately granted defendant's motion for summary judgment, not because of litigation misconduct, because of lack of evidence to support the plaintiff's case. So, Judge Peck, what do you think about the defendant refusing to negotiate search terms with the plaintiffs? Do they bear any responsibility for the overly narrow search terms that the plaintiffs wound up using?
Yes. The parties, Rule 1, the parties have an obligation to meet in good faith on various and sundry discovery-related issues. And we don't seem to know here why defendants refused to meet and confer here. Maybe it was when plaintiff was pro se, maybe it was because whatever concessions the defendants made were just being used against them in the search term negotiations. We don't know. But, that makes them partially at fault. But the producing party, and this is really the flip of Sedona Principle 6, that the producing party is in the best position to know its client's documents and, how to deal with it. So the main obligation was on the producing party here. And clearly from Judge Lyman's opinion, they either were fairly shall we say, unknowledgeable about search procedures and clear search methodology, or they were working with their client to produce as little as possible. So it's plaintiff's main fault. Might have been helped if defendants cooperated in discussing it, but might not have.
Sure. Yeah. I mean, it sounds like plaintiffs were difficult to deal with, so that could have been, maybe that could be a reason for sure. So, Mary, if the plaintiffs hadn't been so delinquent with their document production, do you think they would have been given a chance to correct the scope of their search terms?
Well, I think so. I mean, certainly this was one of those rule 1.1s, don't piss off the judge. But this was also one of the most aggressive data reduction exercises that they took on themselves unilaterally. I mean, they narrowed the custodian set by themselves. Okay. And then they narrowed it further to say only those emails going back and forth among the people that we've named. And then the search terms they chose, they didn't just, have regular search terms. They had within 10. So COVID-19 within 10 of CDC, narrowing it even further. It's no wonder they got like little eyedroppers full of documents in the beginning there. And it was, the 1,000 documents was perceived to be a deluge. Yeah.
Yeah, absolutely. So, Tom, what responsibility does plaintiff's counsel have here, given that they were the second counsel in after the case was originally filed pro se, and the client appears to have been a difficult client to work with?
Well, they have all the responsibility in the world. The judge didn't mince any words, as you just read. They had an independent obligation to craft search terms to fulfill the requirements of Rules 26 and 34. I mean, yeah, they came in late. Yeah, they had a troublesome client, yada, 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 yada. But they still, as both the judge and Mary have pointed out, they limited not only their search terms, but the custodians. Mm-hmm. I mean, I'm reading this and I'm thinking that in Judge Peck's offering of two alternatives, I'm taking door number 2. They did everything they could to produce as little as possible. So I think it's all on them in terms of this particular search.
Yeah, certainly seems that way. And certainly
it always, Doug, it always amazed me when I was still on the bench where one attorney withdrew, then maybe a second counsel withdrew, and then the third counsel comes in thinking everything is going to be wonderful and is just shocked to find out that the client is difficult, et cetera, et cetera. Got to be careful, however desperate one may be, in picking one's clients.
Yep. Yes. Certainly the first counsel for the plaintiffs looks a bit smarter for withdrawing when they did. So, yeah, great point. All right, we'll move on to our last case, which is an MDL involving the chronic myeloid leukemia drug Tasigna from Novartis, where Novartis was directed to designate with particularity the discovery sought from plaintiffs and to meet and confer to agree on the proper scope. Any unresolved objections were required to be presented to the court. So there were 4 areas of disagreement, which the court addressed at a hearing on September 15, 2023. It was apparently not a good hearing for the plaintiffs. Regarding plaintiff's social media, Florida Magistrate Judge David Baker stated, plaintiffs argue that ESI and their social media should be searched using search terms. Novartis argues plaintiffs should use a tool such as download your information to produce everything that is pulled. Novartis has made the showing that search terms cannot be tailored sufficiently to capture responsive social media postings, particularly given the often casual nature of such discourse. Subject to the timeframes and any other limits parties have agreed to, plaintiff's social media ESI will be produced in full. If an individual plaintiff's circumstance are unusual, the individual plaintiff can seek further protection from the court. If broad areas of the downloads have nothing to do with the matters in this case, and there's a way to segregate such material after the appropriate meet and confer, plaintiff can file a motion for further limitation. Regarding search terms to be used on ESI in electronic devices, Judge Baker stated, plaintiffs state that they intend to conduct a reasonable manual search of their devices for any responsive documents without the use of search terms. to the extent they intend to perform a manual search on their devices, unless they're going to undertake to certify that they have reviewed every piece of ESI in the device during the manual search and nothing responsive has been found, the devices should be put through a technical search process to apply search terms in finding the responsive documents. With respect to the search terms that defendants propose, plaintiffs' objections to certain terms are overruled. Judge Baker also overruled plaintiffs' objections regarding production beyond the 16 categories in the plaintiff fact sheets and employment-related discovery and photographs as well. Summary, Judge Baker stated that plaintiffs have not made a showing beyond a broad brush for the burdensomeness of the discoveries sought. Now, of course, we don't know what their specific objections are because it was kind of a short ruling, but what information could they have offered or should they have offered to provide some specificity to their objections on things like social media production and objections to search terms?
Yeah, good question. In what you just read from the judge, the devices should be put through a technical search process to apply search terms and finding the responsive documents. They've got something they're calling a technical search process. And so taking those words, the technical search process across the different data types that you're trying to demonstrate are too burdensome would go a long way to showing how much relevant data is in there, how much non-responsive data is in there, how long does it take to do this, how burdensome is it in actual numbers rather than the broad brush. And that's what they need to do.
Yeah, no doubt about it. So Tom, this was a very brief ruling, and just about every ruling went against the plaintiff. So do you think that Judge Baker should have provided more detail to justify his rulings?
No. And the reason I think that is because, as Mary just pointed out, and the judge himself stated, there hasn't been any showing beyond a broad brush for what's going on here. I think that the plaintiffs have put the fence around this, and the judge is working inside that fence that they constructed. He left the door open several times. You had some quotes there. If there's individual and specific communications or genuine burdens beyond the ordinary, following a meet and confer, they may request a hearing. Further on, if an issue is raised in a particular case, such discovery requests can be revisited. I mean, I think he was very clearly saying to them, it's up to you to make this more specific. And if you're going to, as I said, put a very, very broad fence around this, I'm simply going to respond accordingly.
And I just want to add one thing to that. Most federal magistrate judges, most judges have an incredibly busy docket.
Yeah.
And their job is to rule for the parties before them. It's nice when you get an opinion with more detail that can be a lesson, for use in other cases, without going to the far extreme of DR distributors, the war and peace of the discovery decisions.
Right.
But, if the judge wrote enough for these parties to know what they had to do, that's the judge's job. More is nice, but not required.
Yeah. I should also say, I think in that next to last paragraph there, Doug, I thought that perhaps the judge's spidey sense went up a little bit when he read that, or stated that the plaintiff state that they intend to conduct a reasonable manual search of the devices. And then, went on to the extent they intend to perform a manual search, unless they're going to undertake to certify they've reviewed every piece of ESI in every device. You should be using some sort of a technical search process. I mean, he certainly seems to be saying, I'm not kind of comfortable with the way this thing is starting out here. Mm-hmm. And remember, it's an MDL, which means right. I think he only limited it to 5 of the underlying cases here, but the implications for all of this in terms of the scope of an MDL can be significant.
Yeah, absolutely, and and absolutely to Judge Peck's point. Certainly, I can understand. There's not an obligation to provide that. Yeah, it certainly would have been interesting to see what the objections to the search terms. Because obviously it's one thing to require them to do search terms, but their objections to the search terms were just overruled. Just as a matter of course. So would have been great to get a little more detail there, but it is what it is. Hey, it was a short case that was easy to read to pick for the webinar, so I'm not going to complain about that, right? So Judge Peck, given privacy considerations of not just the individual plaintiffs, but also maybe their friends and connections who may not be affiliated with the case at all, do you think the order to have plaintiffs produce their social media in full is an overreach?
No, I don't. First of all, it's up to the parties to make the arguments they want the court to rule on. From what we can see from this opinion, plaintiffs didn't argue that there were privacy concerns at issue. They just wanted to use keywords to search social media. And as the judge correctly said, in general, keywords don't work very well against Facebook posts and the like. So, if you don't make the argument to the court, some judges might bring it up on their own, but don't hold your breath waiting for that. The other thing is, and maybe, I am not on Facebook. I've never been on Facebook. I am on LinkedIn, which is sort of social media. It's pretty public. So maybe hard to get at without the plaintiff's assistance. Maybe they do have limitations on who can access their social media posts, but it's not something where one would expect to see much in the way of privacy. And finally, and most importantly, as you've all pointed out, the judge gave you have a second chance. If there is something that is super private or, something that's a big problem, meet and confer, and you can come back to the court and we'll separate that out from the rest of it. Short opinion, but a good one.
Yeah, very interesting one for sure. So now for the contacts page, and our next case law webinar is exactly 3 weeks from today on eDiscovery Day, Thursday, December 7th, where we'll discuss the 5 most important cases of 2023. Alas, the diisocyanates case, I was going to say it right this time, was last year. So we won't get to hear Judge Peck pronounce that again unless he refers to it. But we will have 5 very interesting cases to talk about, and we'll send out a link to register for that one in our email after this webinar. So,
and just a note that we will not be on 24 for that. We'll be on the eDiscovery Day platform of Xtero.
Correct. Yes. And we will send, and the link that we send out will be for that platform. So all of you who are attending will get that link and you can register accordingly. With that, I'll say thanks to Mary, Tom, and Judge Peck for their terrific insights as always. And I'll turn it back over to you, Mary.
Well, thanks, Doug. And we thank you and eDiscovery today for bringing this to us with Tom O'Connor and the Honorable Judge Peck. It's a wonderful thing to do, Doug. Thank you. And our thanks to the EDRM community for your kind attention. We'll see you next time on the EDRM Global Webinar channel. Thank you.
Bye, everybody.
Thanks, everyone.
Bye all.
Happy birthday, Kaylee.